thank you everyone for joining us today for our webinar on positive employee relations, protected concerted activity, and union organizing. We'll be covering a lot today. This is the third in our labor and employment webinar series, and we'll talk about the schedule at the end of the slides. Let me take the time right now to introduce myself. I am Kara Maciel. I'm chair of the firm's labor and employment practice. I founded this firm with my partner, Eric Kahn, almost a little over 10 years ago now, about 10 and a half years ago. And this is my bread and butter, what we're going to be talking about today. So I represent unionized and non-unionized lawyers on their rights under the National Labor Relations Act, the federal law that covers federal labor law. For unionized companies, I serve as chief negotiator at the collective bargaining table. I represent employers if they're facing union election campaigns. I also do a lot of training for non-union workplaces on rights and responsibilities under the National Labor Relations Act and what supervisors should know in order to make sure they understand their obligations under the Act, and as well as training to keep positive employee relations to avoid union interference. I'm also an employment litigator, so I do a lot of employment litigation at the federal and state level and do a lot of training in addition to labor relations, but also harassment, retaliation, and other employment-related statutes across the country. Joining me is my colleague, Letitia Silas, and I will let her introduce herself.
Hi, everyone. Like Kara said, my name is Letitia Silas. I'm a partner here with CMC in the Labor and Employment Practice Group. In addition to everything that Kara says that she does in the traditional labor space and collective bargaining space, I have been working in this space for over a decade, both in-house, outside counsel roles, executive roles, most recently with the University of California, where I oversaw the labor relations for the entire UC system, all 10 of their campuses, their 5 medical centers, and their National Research Laboratory. I started my career with the National Labor Relations Board as an investigator and trial attorney. The NLRB is the agency that enforces the law that we are going to cover today. So I look forward to hopping into this with you and sharing what we know.
Great. All right, Letitia's going to kick it off with the agenda, and and her and I are going to kind of trade back and forth on the different topics. Letitia, off to you.
Yeah, so today we're going to start off with an overview of the National Labor Relations Act. Then we're going to go into what the NLRB might look like under the Trump administration. Then we are going to dive into Section 7 activity, and that's really the heart of the National Labor Relations Act. So we are going to cover protected concerted activity and union activity. And then finally, we are going to conclude with a presentation on positive employee relations. So let's start first with an overview of the National Labor Relations Act. This is an old law. This law goes back to 1935. And unlike any other federal law, the National Labor Relations Act really regulates workplace relationship dynamics. It applies to private employers whether or not they are unionized. I'll say that again. The National Labor Relations Act applies to your business whether or not you have a union. It protects employees' rights to engage in certain activity. And it also excludes from protection supervisors, managers, agents of the employer, and independent contractors. They are not protected under this act. Now, supervisor, managerial employee, agent, and independent contractors are all specifically defined under the National Labor Relations Act in the statute itself or by case law. So please seek appropriate counsel when trying to determine if someone is covered or not covered by this law. This law also governs the relationship between employers and their employees, unions and employees, and unions and employers. It gives employees the right to engage in protected concerted activity for mutual aid and protection. That means banding together to address issues or confront management on issues concerning their terms and conditions of employment. It also grants employees the rights to form, join, or assist labor organizations, which we know to be unions. It prohibits discrimination because of protected concerted activity or union activity. And it also requires employers and unions to bargain in good faith over terms and conditions of employment once the union is the recognized representative of the employees. And finally, this act also governs union conduct because it requires unions to fairly represent individual members of the bargaining units they represent, as well as collective members. So why does this matter to you? This matters to you because the act, the federal labor law, impacts your employee relations, your business decisions, your operational decisions, your property rights. For example, who has access to your property? Like, who has the right to come to your property and engage in certain activities, organizing activities? Is it just your employees, or does it some of the time include non-employee union organizers? And finally, this law impacts your reputation and your brand. We have seen this happen in the news repeatedly over the last, I want to say, at least the last 5 years, where notable brands have been adversely impacted by their labor relations and their compliance with the National Labor Relations Act. So I'm going to turn this over to Kara, who is going to talk about the NLRB under Trump.
Okay, thanks, Letitia. So yeah, January, we've got a new administration in Washington, and certainly because the National Labor Relations Board, which is the federal agency that enforces the National Labor Relations Act that Letitia was just talking about, that is a board that is usually dictates by the president, the administration that is in office. So currently, we have a few members of the board that, as I said, it's a federal agency. It's got different branches. The board itself is made up of 5 members. They are the ones that sort of decide. They're like the judges. They decide cases that come up through the system based on administrative proceedings at the regional level. The board members are typically appointed by the president to 5-year terms. The idea is that they're staggered over those 5 years so that there's some continuity as the administration changes. Those members have to be confirmed by the U.S. Senate. And again, with one term of the member expiring each year, although you'll see, and I'll talk about this in a slide or two, that has changed a little bit under the current administration. In addition to the board, there is, as I mentioned, these division of judges, administrative law judges, who preside over hearings that are raised after a region across the country might find a complaint for an unfair labor practice. If a region investigates, issues a complaint, that is then heard by an administrative law judge across the country based on where it's located. And those hearings generally, have the similar burden of proof as a trial, but it's not in front of a jury. It's very informal. Often rules of evidence aren't even considered. You're in a hearing room, and the administrative law judge can dictate the type of evidence he or she may want to hear in order to issue a ruling on the contested issue. A very important person that's involved with the board is the general counsel. Again, this person is appointed by the president to a 4-year term. The idea is this individual is independent from the board, although in the past, I would say 2 or 3 administrations, that has not been the case. The general counsel has been a very powerful position that really dictates where the board is going to be issuing its cases. So oftentimes it is that general counsel that issues what's called an advice memoranda and dictates, these are the types of cases, regions across the country, that I want you to find, issue complaints on, get them heard before an administrative law judge so they can come up the pipeline before the full board and be able to issue binding case law that will be powerful for all all employers, unionized and non-unionized, on a variety of issues. And we're going to talk about some of those hot button cases in a minute or two. So here currently is the state of the National Labor Relations Board as we sit here March 12th, 2025. Marvin Kaplan is currently the acting chair. President Trump has named him the acting chair a few weeks after he took office. Mr. Kaplan has been on the board as a member for a long time. He, I believe, was first nominated even during the first Trump administration. He stayed on and was renominated during the Biden administration. He comes before the board, he comes from the OSHRC, this is the OSHA Review Commission. So he has had long-standing kind of federal civil service, and he has, I think will lead the board in a strong way. There are 2 vacant positions, as you see, and traditionally those would be nominated by the president, approved by the Senate. Currently, those are vacant. So we've got arguably a 3-member board. David Prouty is the other member of the board that has stayed on through the Trump administration without interruption. He has been nominated by President Biden. He is a Democratic individual on the board, former union attorney. His term expires next year, unless we see something happen sooner. The typical expiration date is August of 2026. And then we come to Gwen Wilcox. She was terminated, fired by President Trump last month, which was unusual. As I mentioned, the board members have a 5-year term, and the idea is that their terms expire over the course of a time in order to allow there to be continuity over a new administration. President Trump did fire her in September last month. She has filed a lawsuit against that removal, claiming that removal was unconstitutional. A U.S. district judge in the District of Columbia a week or so ago issued, in fact, it was last Thursday to be exact, Judge Howell issued her ruling and reinstated member Wilcox to the board, finding that her removal was unconstitutional. President Trump has appealed that ruling to the appellate court, the U.S. U.S. Court of Appeals for the District of Columbia. But while that appeal is pending, she has been reinstated to the board. As of yesterday, believe it or not, she and Member Prouty and Acting Chair Kaplan are issuing decisions. There were four decisions that were issued yesterday, non-controversial decisions, things that should be just sort of rubber stamped, nothing really that issued any kind of written opinion. It were cases where the parties didn't file objections to the administrative law judge's decision. So essentially was, again, rubber stamping the ALJ's decision. But that being said, it's a little unusual right now that we've got Member Wilcox, who is in this quasi status of being reinstated by a trial court, and whether that reinstatement will stand at the appellate court, we'll see. If she is not reinstated, if she does not stay on the board, that leaves Marvin Kaplan and Member Prouty to be on the board, and that does not have a quorum. So without a 3rd member of the board is essentially at a standstill. The board members can review cases, they can look at the opinions, they can consider how they might rule, but they can't issue any rulings if it is just the 2 of them. They need a 3rd member on. I would imagine if Member Wilcox remains on the board by the Court of Appeals, we will likely see one or more members being nominated by President Trump quickly, so that there can be a more of a conservative Republican majority to the board with a 3-2 ruling in order to maybe change some of the ways that the board has acted or cases that they've ruled on during the Biden administration. We'll talk a little bit more about that in a second. These are some of these issues, the cases that likely are ripe for change once we get a Republican majority on the board. First thing is employee self-determination, right? The idea that employees and employers are obligated to recognize and bargain, right? Bargain with the union without an election. If there's certain conditions, or if the union has filed an unfair labor practice during the time when they're organizing or seeking a demand for recognition. So right now there is the right to file an election, and that election goes to, a free and fair representation, secret ballot election. But there is board law currently that allows for automatic recognition. And so we expect that to be an issue of change, indicated already by the general counsel, the acting general counsel, but we think board law should change on that when a Republican majority takes over. Another controversial decision that happened at the end of the Biden administration was a case about employer speech and campaign rights. So there was a case called captive audience speeches that limited the employer's rights to be able to speak to their employees during an organizing campaign about the impact of unionization on the workplace and what they're able to say during those meetings, what are called, and again, mandatory captive audience meetings. Those meetings have been lawful for decades and decades. The board overruled that late last year. And again, we expect that to be an issue that would be ripe for change under a new board. Also, too, there is a case out there that says if you have a severance agreement or that includes confidentiality or non-disparagement with an employee that is protected by the National Labor Relations Act, that's going to be an hourly employee, a non-manager, non-supervisor, as those terms are defined by the Act, as Letitia alluded to earlier. Generally, those clauses are considered unlawful, and even presenting an agreement to an employee is an unfair labor practice. We expect a new board to overturn that case as well. And then finally, I will talk about this at the very end of the presentation today, this idea of potentially overruling this stricter standard for when a workplace rule would be considered violative of an employee's Section 7 rights, the right to engage in protected concerted activity. Letitia's going to spend a lot of time in the next minute or two talking about protected concerted activity, but we've seen this ping pong approach from the board over what is a lawful handbook rule. Popular rules like confidentiality or cameras in the workplace or maintaining a uniform policy, what you can require employees to wear or not wear at work. Those types of workplace rules have been banted around under different standards. So we hope to see a new board kind of lighten the strict standard for what is reasonable and what is not for purposes of protected concerted activity. There is a new acting general counsel. His name is Bill Cowan. He, again, was appointed by the president, technically supposed to be independent from the board, and he's the prosecutor of the board. He's the one, as I mentioned earlier, he's investigating, prosecuting unfair labor practices, directing the regions across the country, what they should be doing and how they should be handling unfair labor practice, as well as union representation petitions. He was appointed last month after the current general counsel, Jennifer Abruzio, was removed by President Trump. She was a Biden appointee. He had previously served as regional director in LA for many years. And prior to that, he actually served as the solicitor and was the chief legal officer. So he has a long-standing knowledge of the board, its processes, its procedures, and really comes to this role really highly skilled and knowledgeable in how to move the board forward. What we do think he will be doing is moving and shifting away from the memoranda that and the direction that the former general counsel had done. He almost immediately issued a new memo. It's General Counsel Memo 2505, which said, again, pending further guidance, these are some things that regions I'm really not interested in you focusing on. So one is guidance about the board's decision in CMEX, which I alluded to previously, which allows for automatic recognition of a union without a representation election. Previously, there have been a lot of interagency cooperation between the board, between the EEOC, even between the Department of Labor. A lot of interagency cooperation over unlawful practices. He has reversed that. Other things include, removing the employer's restriction on allowing to be monitoring employees if they need to through AI or other documented monitoring techniques. Expanding remedies beyond kind of traditionally make whole, as had been defined by the board. And then as I mentioned, this confidentiality non-disparagement provision, even though that's still current board law, as is the non-compete stay or pay provision, he is moving in that direction away from enforcing those cases. It is still board law. I will say, over the winter, there are a lot of meetings that the federal agency has. And just last week, Letitia was able to participate in a meeting where acting General Counsel Cowan presented on his vision of the board, and I'm going to let her chime in on what she learned during that conference.
Thank you, Kara. So I attended the Developing Labor Law Conference a couple weeks ago. And this is, for those of you who don't know, this is the conference for traditional labor attorneys across the country. All the major players are there, as well as even the major players within the NLRB itself, including board members and the general counsel. So this year, the acting general counsel was present. And I just have a few takeaways based on my understanding and observations of his presentation and discussion on a panel. So my understanding is that he will be directing regional offices to return to the bread and butter of investigations of unfair labor practice charges, prosecution of those cases, and conducting union elections, and will not encourage the regions to pursue more novel theories to expand the law. My understanding is that his focus is going to be on clearing the backlog of cases within the regions. If cases have been lingering, regions will be instructed to pursue settlement. There was also some discussion about perhaps the regions returning to the 80% policy, meaning that you could get a board settlement of a case based on 80% of the total make whole back pay due. And that had changed under the former GC Abruzzo's watch because she was demanding 100%. So there is some conversation about returning to the 80% standard, but there's nothing etched in stone yet in that space. My understanding is that individuals, businesses, unions are encouraged to continue filing their charges and petitions, business as usual. There was no conversation suggesting that the acting GC intends to push pause on the operations of the agency. Compliance with existing federal law is still expected. So that means compliance with CMEX, as Kara talked about, is still expected. Compliance with McLaren-Macomb, which talked about severance agreements with confidentiality provisions in there, that is still expected to be adhered to. The acting general counsel may issue a memo on mandatory submissions to advice for establishing a new general counsel agenda and prosecutorial direction. So now we're going to go into really the bread and butter, meat and potatoes of the National Labor Relations Act, and that is Section 7 activity. Now, just to recap, Section 7 activity includes the right to engage in protected concerted activity for mutual aid and protection, and the right to engage in certain union activity. So first, we're going to start with protected concerted activity for mutual aid and protection, and I'm just going to refer to the acronym PCA. So PCA includes an employee when an employee's conduct is engaged in with or on behalf of other employees and not solely and on behalf of the employee herself. This includes individual employees seeking to initiate or induce or to prepare for group action concerning their terms and conditions of employment. So what does that mean? That means employees talking to each other and say, hey, join me in filing a wage and hour complaint, or join me in filing a EEO complaint, or join me in writing a petition to the supervisor complaining of protesting our working conditions. It also includes individual employees taking action on issues of common concern. So what does that mean? That means maybe there's an individual employee who files a complaint, but the matter is something that impacts more than just that employee. So although it is a single employee engaging in the action, it is based on an issue of common concern. I think we're going to see more of this in the DEI space, really. This also includes employees bringing truly group complaints or complaints regarding terms and conditions of employment to the attention of management. It doesn't have to be a formal written complaint. It could just be employees walking into a supervisor's office, or just raising issues during a staff meeting or a huddle. It doesn't have to be anything formal. PCA also includes individual employee action that is the logical outgrowth of employees' prior or ongoing protected concerted activity. And we're going to talk about that more in just a second. All right, so let's get into some examples of PCA and how it can show up when two or more employees are acting together regarding or discussing their wages, hours, and terms and conditions of employment. So for example, employees Rami and Felicia talk to a reporter about how much money they make and the lack of a cost of living increase while management receives huge bonuses at the end of the year. That is protected concerted activity. I know that there are a lot of employer rules out there that prohibit employees from talking to the media, right? But employees do have a protected right to talk to the media concerning their terms and conditions of employment. What they cannot do is purport to speak on behalf of the company, right? So you want to make sure when we get to that section on rules that you are thinking about your rules in that space. Another example is employees Lynn, Rachel, Kim, Rami, and Carlos comment on social media that their supervisor is creating a hostile work environment. Coworker Joe likes the comment and says his mental health is suffering. Yes, even posting on social media, even having conversations in the virtual space is considered protected concerted activity. Even the use of emojis or just simply liking a comment could be considered protected concerted activity. So if you are coming across this in your workplace, you should be consulting with legal counsel so that they can help you navigate this space and know where your opportunities and vulnerabilities are. More examples of protected concerted activity. This one has to do with when employees complain about a work issue that impacts more than just that single employee or that is intended to initiate group action. Now, I talked about that a little earlier, but here are a few more examples. One employee writes a letter to the president or CEO of the company regarding working conditions in the department generally. Could be considered protected concerted activity. An employee files an OSHA complaint regarding working conditions in the department or on the premises. Again, although raised by a single employee, this could still be protected concerted activity and in fact has been found to be protected concerted activity. An employee solicits coworkers to file or support an EEO complaint or any other type of complaint is protected concerted activity, even though it's a single employee who's really initiating that action. Now let's talk about what it means for PCA to be a logical outgrowth of PCA, right? So a single employee confronts management or protests working conditions after having discussed that subject with coworkers, right? So here's an example. 3 employees discuss the return to the office mandate. 3 weeks later, one of those employees writes the supervisor an email challenging the supervisor's remote work while employees are required to be in the office. That is still considered protected concerted activity. Why? Because this single employee had previously discussed this issue with his or her coworkers, and now they are bringing that to the attention of management. Other common types of PCA that are often misunderstood or overlooked, and that's why I encourage you to seek counsel if these things come up in your enterprise. For example, discussing salaries, bonuses, promotions, and performance appraisals, that's all protected concerted activity. Those things are not confidential. Group complaints made to a supervisor, executives, and yes, even the board members, right? The board of trustees. If it concerns terms and conditions of employment impacting more than just that individual employee, yes, that is considered protected concerted activity. Comments to clients or customers about working conditions, yes, that is considered protected concerted activity. Wearing social justice insignia For example, Black Lives Matters pins, which we just recently had a board case come down on that subject. Yes, that is considered protected concerted activity if it is done in connection with terms and conditions of employment. So is wearing union insignia in the workplace, right? So we can get into more detail on that. We'll be having a master class later on. We will make the distinctions between what is protected and unprotected and how we enforce our rules around wearing certain insignia in the workplace. But for now, this is the basics. Next, complaints to state and federal agencies such as OSHA and EEOC. Refusing to work in or photographing unsafe working conditions or operate unsafe equipment. That is protected concerted activity. So again, if you have rules on, prohibiting cameras in the workplace or recordings or photographs in the workplace, please be consulting with legal counsel so that they can help you formulate a rule that could pass scrutiny, right? And then also protect you from liability. Finally, photographing and recording in the workplace. That's not only video recording, but that's audio recording. Yes, there are certain wiretapping laws at the state level that we should be mindful of, employees should be mindful of, and that we should obviously as employers be asserting. But just know that generally speaking, yes, there is a protected right to photograph and record video and audio in the workplace if it concerns terms and conditions of employment. So I just want to give a hypo here. Employee George was suspended from his job as a food production employee at Bread and Butter Company. During his suspension, he posts a video on TikTok and YouTube entitled, "What You Need to Know Before Working at Overnight Baking Company." In the video, George tells various stories claiming that working conditions are unsafe and that the company's processes are unsanitary. He posts recordings of what purports to be the production floor and unclean equipment. The question is George engaged in protected concerted activity? So I'm going to leave you with that. I'm not going to answer the question for you. I'm going to leave you with that to give you something to think about when you get these slides after this webinar and you have a chance to review everything that we've covered here. All right. Conduct that is not protected concerted activity. This is conduct that does not have the protections of federal labor law. And that's individual employee gripes and complaints only affecting that single employee, the remedy for which will only flow to that employee. We've all seen this employee. This employee doesn't want to work. They don't like their job assignment. They don't like the supervisor. They just don't like anything. And every complaint has to do with me, myself, and I. That is not protected concerted activity. Insubordination, most of the time, is not protected concerted activity. There are some exceptions where an employee may be refusing to engage in illegal conduct or refusing to engage in unsafe conduct. But again, be consulting legal counsel around this space. Generally speaking, however, the rule is comply now, grieve or complain later. But insubordination is not protected activity. Violence and abuse are not protected activity. Now, there's like a sliver of space in this rule where if the conduct is on the strike line. So if you're dealing with a strike and there's some strike line conduct happening that you think is violent or abusive, please be consulting with counsel on that so that they can help you navigate that space. Making maliciously false and knowingly false statements is not protected conduct. Illegal conduct is not protected conduct. Conduct that is not intended to enlist the support of other employees, also not protected. Conduct unrelated to terms and conditions of employment. Just because we like this social justice issue, we're going to talk about it at work, does not make it protected concerted activity if it has nothing to do with the terms and conditions of employment in that workplace. So what is our obligation? Our obligation as employers is to not threaten employees, not interrogate employees, not poll employees, and not surveil employees in the conduct of their protected concerted activity or even union activity, which we'll get to in just a second. The National Labor Relations Act calls this interference, restraint, or coercion. So what does threatening employees look like? It's either an express threat. If you do this, then I'm going to take this adverse action against you. Or it's an implied threat, such as, if you don't like it here, you can go work somewhere else. We all know a notable coffee brand whose CEO said that, and the board found that that was that violated the National Labor Relations Act because it was coercive, because employees would understand that statement to mean that they could be fired for their protected activity. Not interrogating employees includes not asking them questions directly about their protected concerted activity, but also not making statements intended to elicit from the employees an admission or denial of engaging in protected concerted activities. Also, not polling employees. For example, walking into a meeting and saying, well, who all supports Jane Doe's protests over return to work? Raise your hand. That it would be interfering or coercing employees in the exercise of their Section 7 Section 7 rights, pardon me. Also, we should not promise to make changes to working conditions to discourage employees from engaging in protected concerted activity or union activity. Finally, not surveilling employees. That means spying on employees or creating the impression that we are spying on employees as they engage in their protected activities or union activity. So what are some examples of interference and coercion? More examples are expressing disappointment about employees' protected activity or saying that the activity is disloyal or a betrayal. I've seen case after case like this, especially when I was a prosecutor for the NLRB. Cases come through with where a supervisor says to an employee, you know, I really trusted you and I can't believe you did this to me and this is very disloyal. I feel like you betrayed me. That would violate the National Labor Relations Act. Withholding benefits from employees to discourage them from engaging in protected activity or union activity. For example, denying OT all of a sudden, overtime all of a sudden, or not giving the premium pay assignments. I've seen that lots of times as a prosecutor. Also, creating more onerous work assignments or working conditions for employees, and stricter enforcement of the rules, meaning 1 minute late is late. That if you don't always impose a 1 minute late is late rule to suddenly do it while employees are engaged in protected activity or union activity would violate the National Labor Relations Act. So next we're going to talk about union activity. So we are still in this space of Section 7 activity. So let's first talk about some of the main reasons that employees decide that they want to form a union. And one main reason that I found in my career is sometimes it's just ideological. Sometimes it's not about the employer being a, quote, bad employer or not paying fair wages. Sometimes it's just this is what the employees believe and they believe they have this right, and so they want to exercise that right. And we're seeing that more and more with the newer generations coming into the workplace. Other reasons include some of the traditional ones like money and benefits, job security and workload. We're seeing that a lot more as well, especially in the higher education space. Health and safety concerns. Discrimination, harassment, and abuse would be a reason why employees decide that they want to form a union. Unfair, arbitrary, or inconsistent application of rules and policies. I usually see this where there's a supervisor who has a favorite and is playing favoritism, and employees don't like that, and so they decide that they want union representation to make everything fair and predictable. When employees feel disrespected or unheard, that could cause them to want to form a union because they believe that the union could get them the respect they feel they deserve and can also act as a voice that the employer will respond to. A lack of training, development, or growth opportunities is another reason why employees decide they want to unionize. A lack of engagement and communication. If employees just feel like they don't know what's going on in the organization, they're expected to come to work and put their head down and just, toil all day and not ask any questions, don't expect any answers. Well, they might decide that they need a union to go help them get some sort of communication and engagement from management. And finally, we are seeing this more currently in the space that, an employer not taking a position on a social justice issue could be a reason why employees decide they want to form a union. And as I noted earlier, I think we might see more of this, especially in the DEI space, as more and more companies are changing their policies around that. So the National Labor Relations Act gives employees the right to form, join, or assist unions and to engage in union activity. So I tried to organize this slide so that it covers activity that is union activity, even if there is no union that represents the employer's employees, as well as activity that an employee can engage in if the union is their representative. So some activity, if the union, even if there's no union on site, that is still considered union activity, is soliciting coworkers to join a union or going on strike. You don't need a union to go on strike, right? Employees can just go on strike without a union. Communicating about union members to each other, wearing union insignia in the workplace, again, complaining to the union or attending union meetings. Some other conduct that's union activity that really only exists if there is a union that represents the employees includes filing union grievances through a collective bargaining process, asserting the terms of a collective bargaining agreement, or the right to have a union representative present at investigatory meetings or hearings conducted by the employer. So the right to engage in protected concerted activity and union activity also includes the right to refrain from doing so, right? So everything that I said employees have the right to do, they also have a right to refrain from doing so, and we should likewise avoid interfering with their right or coercing them in their right or doing anything to encourage or discourage their right to resist PCA or union activity. So that includes they have a right to resist unionization. They have a right to choose not to complain to a union. They have the right to choose not to have a union rep present at investigatory meetings. They have a right, if there is union representation, to be a non-member, meaning a core fee member of the bargaining unit. They have a right to resist or engage in efforts to decertify a union. So I'm going to turn this over to my colleague, Kara, who's going to cover positive employee relations.
Thanks, Letitia. All right, so really a part of this presentation is to make sure that you want to maintain, if you are union-free currently, you might want to maintain that union-free environment. And the way to do that is to ensure positive employee relations. Think back when you're, going back to your office or you're talking with other members of your team, go back to Letitia's slide about the top 10 reasons why employees unionize. And other than taking aside ideology off the table, look through some of those concerns, the health and safety concerns. Are your wages and benefits competitive? You probably do market studies, probably understood that where you might need to increase wages in a unionized environment, if you're non-union, things of making sure you're offering competitive benefits, those things. But job security, workload, making sure people have the tools to do their job, making sure that they are spending their time at your workplace, which is probably more in that 8-hour time that they're working with their supervisors, with their coworkers, than they spend, awake at home even. And so you want to make sure that environment, that workplace really is a positive environment so that they don't need to ever turn and go and seek third-party union interference. Some strategies in doing that is, as Letitia's talked about in terms of the reasons why they unionize, but also too, there's things that you as managers can do. Number one, management training and knowledge. We do that training all the time for our clients. We come in and we do Labor 101 for supervisors and managers, those true supervisors and managers that are excluded from the act, as Letitia mentioned. We do a training on, what are unions? How do they organize? What kind of things would you see if someone were coming in to try and organize? Importantly, what can you say as a supervisor? And what can you not say as a supervisor so you're not falling into an unfair labor practice trap? So not only do we do individual trainings, as Letitia mentioned, we're going to be doing a master class in the next month or two, where we really hope to dive into the really nitty and gritty of the topics we're talking about today and really help employers really know where their obligations are under Section 7 and how to maintain a positive union-free environment. So stay tuned for our master class. Making sure you empower your supervisors, right? A lot of times when I come in and there's an election or there's organizing, buzzing around, the first thing I say is, who are the supervisors? How do they know their employees? How are they respected? Is there any type of arbitrary discipline? Because the old adage is the unions don't organize, poor managers do. If it is a hot shop, if employees are going to a union organizer and saying, please help us organize, it's because there's something going on in their workplace, usually with a supervisor, either because it's not imposing fair discipline, they're not getting respected, there's some type of harassment or abusive behavior going on. Something is up. And that is something we do when we dive in to find out where is the heart of this organizing campaign. As I mentioned, fair discipline is essential to people feeling that they are being treated fairly, respectfully, and equally across departments and within a department. We talk about, effective communications. This is something we dive into in our training. What you can say, which are facts, opinions, and experiences, and what you want to stay away from. You can never threaten, can never interrogate, can never promise or surveil or spy. Those will lead to unfair labor practices. And then, one of the things that I really like to teach people is the old adage of the 15-minute rule. This is, if you see something, hear about something, learn about something, your supervisor should report that directly up the chain of command to the plant manager, to the general manager, to the director of human resources, to whoever you've assigned in your facility, so that within 15 minutes, you are aware of what's going on at your facility. You immediately call legal counsel within 15 minutes so that you can strategize. Do you need to remove union protesters from your private property? Are they interfering with your front entrance and therefore causing a civil disturbance? Do you need to, collect information if you can to find out who is on your property, which union? Are they trying to talk to employees? Are they trying to interfere with your customer or guest relationships? That's the 15-minute rule. The key is that's a verbal conversation. You pick up the phone, don't text, don't email, because you don't want that information potentially being discoverable during an organizing campaign. Other proactive strategies include non-solicitation defenses. I'm going to talk about that in a second. When we come in and we do a Labor 2.0 training, if there's organizing happening, we talk about our mud lists. And if a petition were presented today, would an employee in a particular department, would they sign it? Or would they be in favor of management? Would they be in favor of a union? Or you don't know. And if I get a list and I see a lot of Ds checked in a particular department, that's telling me there's an issue with the supervisor. The supervisor doesn't really know his or her employees very well. And unless that supervisor just started last week, we need some training, or we need some things to do with that particular supervisor. Other strategies, we talk about integrating departments. So there's cross-utilization, cross-training to expand the potential scope of an employee unit. Talk about, are there issues, workload, policies and procedures, issues that are bubbling up in a department or across company-wide with a top 10 employee issues list. Some companies have adopted a peer review system, which allows employees to challenge disciplinary decisions through a peer board, a peer appeal process that's providing another alternative, similar to a grievance and arbitration provision that they might get in a CBA. And then the importance of employee recognition and awards, just so, again, going back to our theme of positive employee relations, employees feel that they're respected, they're recognized, they're awarded for their attendance, for their birthdays, for their anniversaries, whatever it is. they are recognized for the work that they are doing on behalf of your company. As I talked about earlier, handbook and workplace rules continue to be a hotbed of ULP activity, and that's not going to change, we think, until we may get a ruling from the new board changing what is currently the Stericycle standard of law. And I'm not going to get into too much detail about this because I want to make sure we have some time for questions at the end. But just know, if you have a workplace rule, uniforms. Are you required to wear company uniforms? You have to show up wearing a certain color. You have certain, grooming standards. Make sure you have legal counsel review that policy right now so that it's not overbroad that could infringe on Section 7 rights, like the idea of potentially restricting union insignia or a Black Lives Matter, button, something like that we're starting to see happening, making sure that your rule is narrowly tailored to be able to advance a legitimate and substantial business interest. That's the standard you need to be able to establish, because it's immaterial what your intent is behind the rule. It's how it's written. And if there's any ambiguity in the rule as it's written, it's going to be interpreted against the employer. So this standard has been in place since 2023. We've seen cases bubble up from the former general counsel. I think we will continue to see that in light of what Letitia reported. The acting general counsel, Cowan, is saying still file charges. We are the bread and butter of the board. Workplace rules is part of the bread and butter. So one of the things is, if you haven't already, in Q1 of 2025, now is the time to really take the time to review your handbook, have it reviewed by legal counsel, particularly counsel like Letitia and I that are knowledgeable about labor laws and are up to date about current board law on these types of workplace rules. One workplace rule I want to make sure everybody reviews is your solicitation and distribution rule. Hopefully this is in your handbook. Hopefully, if you are, a place of public accommodation, whether it's a hotel or a grocery store or restaurant or retail store, you've got signs that are posted that say you cannot, solicit my employees while they're at work, or you can't distribute propaganda or leafleting or other materials on work premises. Generally, things that are very broad in that regard are considered unlawful. And so the board has issued more recent case law about crafting those to ensure that employees know that while they're not on working time, while they are on, break area, or they're in an employee parking lot, or they're not in a working area, they can solicit each other. They can distribute information and papers. So that is an important policy to re-review if that hasn't been updated in the last few years. And of course, you can broadly prohibit non-employees from coming on and soliciting your employees who are working, distributing materials. Again, that's where you're going to want to know, where is your public space, where is your private space, and where can you direct people onto public property as appropriate if they are picketing, handing out leafleting to your customers or to your employees who are not working. So with that, we've got about 5 minutes left. I hope people have been engaged. You found this information useful. Here's Letitia and our contact information if you have a question after today's webinar. As I said, I hope everybody knows about our upcoming webinar series. Next month, we'll be talking about trade secrets and restrictive covenants, but we've got a really packed agenda throughout the rest of the year. So we hope you're able to join us for these webinar series throughout the rest of 2025. In addition, Letitia has launched and branded a new podcast with our colleague Samuel Rose. It's called The Terms and Conditions, the podcast. So here's some more information if you want to hear. There's been some really great podcasts over the last couple months, and there'll be many more good topics to come. So stay tuned for that. And then blogs, that's the best way. Signing on to our blogs is the best way to stay informed of updating happenings, both at the federal level, at the NLRB, the agency level, as well as things happening across the country. In California, in October, we're hosting a California Labor and Employment Law Summit. So stay tuned. We've got an early bird special through July.
Well, and I'll add, Kara, to something you said earlier. I want to encourage everybody to go back and look at your handbooks and your policies. Some policies that I have come across that have been deemed to be problematic by the board include confidentiality provisions that make personnel information confidential, overbroad at-will statements that suggest that there's absolutely no way on earth that the employer or that employees could modify their at-will status, use of the company logo, and also conduct or statements that reflect poorly on the company. Those are some things that I see often in handbooks. So go back, look at your handbooks, see if anything sticks out at you, and obviously feel free to reach out to us and let's have a conversation.
So Letitia, let's go back to that hypo that you covered. Is George engaged in PCA?
Okay, so George is suspended. He posts a video on TikTok and YouTube saying this is what you need to know before working at Bread and Butter Company. He tells various stories claiming that working conditions are unsafe. So now we have individual employee posting video and on social media and raising an issue that impacts more than just that employee, because he's saying the working conditions are unsafe and that the company's processes are unsanitary, right? Then he posts a recording of what purports to be the production floor and unclean equipment. So first, we do know that on some level, this conduct is concerted because again, he's raising a concern that would impact more than just him. But is it really true? Is it a false or maliciously false or intentionally false statement to say that the company's processes are unsanitary? And then we would look at, well, wait a minute, he posts a video of a production floor, but whose production floor is it? Is it our production floor? Is it our equipment in the video? And so this would require a legal analysis, right, to answer that question with more information, right? But I would say, generally speaking, at least the posting of the video and talking about working conditions, if nothing else, is part of protected concerted activity. Now, we would have to analyze all the other things, such as, making the statement about unsanitary processes, and then also this video that has been posted.
Yeah, I know, Letitia, I've got a lot of clients that get very concerned when they've got employees who have cameras around a production or manufacturing floor. A lot of that contains proprietary information, could even contain trade secret formulas, things that are very, very highly protected. So I know that's a big concern of clients and how to navigate those types of issues of preventing the disclosure of that information, preventing those types of recordings while also not running afoul of the National Labor Relations Act. So that's a great hypo.
Look at our policies too, Kara. We would want to look at what the policy is on recordings, and maybe there is a business justification for our policy so that we do have a lawful policy. And maybe because we are talking about a baking company and they are dealing with food, I think there would be a business justification for restricting the use of cameras in that area, because what happens if you drop your device in the dough while we're baking the bread, right? So I think we would have a good defense for a restrictive rule on carrying equipment in that area. So we would obviously look at that in analyzing this.
But the other thing though, Letitia, is look, George is by himself. He got suspended. He's probably disgruntled. He's not talking, with other employees. This isn't a Facebook page where anyone else is liking what he wrote. He's on TikTok. He's on YouTube, and he's not in collaboration with other employees. So wouldn't that need to be protected? There'd have to be some concerted activity. What do you think about that?
Well, one question I would ask is whether this is really an individual bringing an issue of common concern to the attention of management or complaining about an issue of common concern. And where this individual is complaining about unsafe working conditions, I think, at least based on this hypo on its face without more facts, that it is raising an issue potentially of common concern, since unsafe working conditions would impact more than just that employee. Compared to when an employee files an OSHA complaint, right? The thought is that, well, the employee filed this OSHA complaint about an unsafe working condition, and if that condition is fixed or remedied, more than just that single employee would benefit, right? Because all employees have an interest in having a safe working environment.
The other thing, Letitia, what about, I mean, doesn't George have an obligation to bring this to his manager's attention so that they have an opportunity to fix it? You know, if he's going off on his own, posting this stuff and hasn't, you know, followed the open door policy, does that change any of your analysis?
No, a couple of things there. So first, no, George does not have an obligation to bring the matter to management. In fact, quite the opposite. There is board law out there that says that if the employer maintains a policy that suggests that employees can only raise their concerns with management and not go raise it externally, then that could potentially interfere with their right to engage in protected concerted activity for mutual aid and protection. So that would be unlawful. What I would say is that we want to get ahead of this as an employer and make sure that we have open lines of communication, and that we remind our employees that we have open lines of communication and that we are responsive. If employees are bringing issues to us, and we say, you can come to us, open communication, but then we don't do anything about the issue, or we don't have any follow-up, then after a while, people say, well, we used to bring concerns to management and they never did anything about it. So we want to make sure we keep those lines of communication open, and that we are actually following up with the employees or taking appropriate action to address their concerns.
Great. Okay, well, we are a little over time, but this was a really great discussion. Thanks, Letitia, for delving into this hypo as we talked about. And again, if anyone has any other questions after today, please don't hesitate to reach out to either myself or to Letitia. We're here to help you. We're here to help navigate these issues, and certainly available to review any handbooks or do any trainings, or really be a resource for any of you that may find yourself in this space. Thanks for joining us.
Thank you.